Okay, good morning. I'm going to call to order the KPPA Ad Hoc Regulation Committee. This is a special meeting, and we're going to begin with an opening statement.
For the record, I want to note that this is a special meeting of the KPPA Ad Hoc Administrative Regulation Committee. This meeting is being broadcast via video teleconference pursuant to Kentucky Revised Statute Section 61.826 and may be viewed by the public at the KPPA offices located at 1260 Louisville Road, Frankfort, Kentucky. It is also being broadcast via Facebook. I ask if you're speaking and not appearing by video, please identify yourself before talking. In the event that the video or audio broadcast is interrupted, we will attempt to reestablish a connection. If a connection cannot be reestablished within 30 minutes, the meeting will be adjourned and rescheduled to another date.
Okay, thanks. Roll call.
Yes, sir. Mr. Piercy?
Here.
Ms. Pendergrass?
Here.
And Mr. Powell?
Here.
Thank you. And there's
Okay.
no public comment today.
No public comment. All right. The next item up is the approval of minutes from our November 15th, 2023 meeting, and I'll seek a motion.
So moved.
I'll second.
Any discussion? Seeing none, all those in favor?
Aye.
Aye. Opposed? And the motion carries. Our first administrative reg is 105 KAR 1001. So Carrie or Jessica, take it away.
Good morning. Yes, so first we have 1001, which adds 8 new definitions to our definitions reg, and it also updates 2 previous definitions that were already in there, and this ensures the use of consistent terminology across all of the Title 105 administrative regulations. This one I think is pretty straightforward. Do we have any questions on this one?
Questions? If not,
No.
I'll seek a motion.
So moved.
I'll second.
Any discussion? All those in favor?
Aye.
Aye. Opposed? And the motion carries. The next administrative reg is 105 KAR 1411.
So this regulation is also an amendment to an existing regulation regarding the administration of the hospital and medical insurance benefits provided by the systems. The amendment to this regulation is we are removing definitions from section 1 that are found in our definitions regulation, updating language throughout to be consistent with all KPPA regulations and the definitions found in our definitions regulation. We also added details to section 4 to indicate the difference between the dollar amount for the contribution rate and the percentage contribution rate that the systems pays for retired members' hospital medical insurance premiums based on membership date or based on hire date. We added clarifying language to section 5 concerning the fee that the recipients may be required to pay for tobacco use or for failure to complete the wellness or well-being promise. We updated section 13 to detail how the dollar contribution reimbursement is applied to recipients with reciprocity, and also how that reimbursement will be applied to a recipient who is on their spouse's insurance, including in another state-administered retirement system. Lastly, we do have that additional recommendation that is needed from the committee regarding the calculations for the dollar contribution reimbursement plan found in section 13. We do have a separate documentation attached that gives an example and outlines the options for that reimbursement. So with that, we'll open up the floor to discuss.
Okay, and I'm actually unfamiliar with this. So is this an actual cash reimbursement, like they get it added to their monthly pension check, or how does this work?
Do you want me to go to that?
Yes, please.
Okay, this was a new reimbursement program that was added in the 22 session, I believe, where it actually allows for a member on the dollar contribution that receives the dollar contribution benefit to receive their insurance, take their insurance somewhere else with an employer through a private insurance company, through their spouse's insurance, and to submit paperwork quarterly for reimbursement for any of the amounts that they pay out for taking their insurance someplace other than through KPPA. Prior to this law going into effect, we did have the out-of-state reimbursement program that allows for members. It's not very used, hardly at all anymore, but previously, many years ago, there were for our retirees who were living out of state that didn't have the same level of coverage that was provided here in Kentucky, it offered them the ability to be reimbursed for the amount we would have paid had they been on a plan here. So it's similar to that out-of-state reimbursement that already existed, but it applies it to the dollar contribution people.
Okay, so and so is this truly cash added to their monthly benefit if they get a reimbursement?
They get a reimbursement. It's a payment through the system quarterly that they are paid through the system. They receive a check for that, right?
Separate check.
Separate check.
A supplemental payment, yes, a separate check.
Okay, okay.
Yeah. So prior to this law, the dollar contribution folks either had the ability to take their insurance through KPPA and receive their benefit, whatever amount that would be, or they didn't receive any of the benefit if they didn't take it through KPPA.
But isn't that the exact condition that exists? I understand we're talking about a law. I'm just trying to understand this. That exact same condition exists on the percentage contribution, right? So if for some reason I'm covered some other way, I can't get reimbursement. So this is truly a benefit that only applies to the dollar contribution folks.
That's correct.
Mr. Piercy, it's because the dollar folks at 20 years are going to get $400 reimbursement. If you're percentage, you get 100% of the premium.
Sure.
That's the reason
right.
the legislators did this.
That's exactly right. I think that was the intent behind this, adding this legislation, adding this law, because of the difference between what a percentage and a dollar contribution member would get, and allows them to find maybe coverage that wouldn't be as costly as our premiums that are applied on our plans here at KPPA through DEI.
But
Okay.
even on the percentage, we establish a dollar amount that's kind of an equivalent because we have an amount that the healthcare committee and the board decide is the premium amount.
Correct.
You only do that for the percentage group. The dollar group is totally defined in law, and the board does not
Sure.
define the money. That's the only difference.
But I think Keith's point was that as a percentage member, he doesn't get to claim that premium amount if he goes to another insurance company.
That's correct.
Yeah. Otherwise, people hired before July 1 of 2003 could go out and shop for a better deal and then pocket the difference if they could find a better deal, right?
Not with the way the law is written, because you would only get reimbursed for what you paid.
Okay.
And they have to prove that. They have to prove it with a insurance form from the insurance provider or a employer they're working for. So
Okay,
that is
makes
captured.
Okay.
So go
I'm
ahead.
sorry, go ahead.
The questions I had were related to the statute language. Does the statute tell us that we need to offset the employer portion before we give them that dollar amount?
No, go ahead.
Yeah,
The statute does not specifically state that, no.
So I'm thinking that that option one is not necessarily in line with the statute. I'm just not sure why we would reduce the statutory contribution just because the member's employer pays something. Now, I wouldn't reimburse them more than the employee actually paid,
Oh, sure, right.
but I wouldn't reduce it because the employer made a contribution.
Carrie, do you want to speak any to the previous court case? That's how it was set up. It was set up that way under the out-of-state reimbursement to consider the employer cost when reimbursing. So that's why it led into this new,
Right.
but do
Did,
you,
did the board approve that policy? Do we know why they did?
So the Keister case, yes, that was based on, at that time, the out-of-state reimbursement had its own regulation. I believe that was $290 at the time. The argument, I was not here at the agency, that was a 2003 case. The arguments from the agency at that time that were ultimately adopted and approved by the Court of Appeal was that for out-of-state members, they would be advantaged over in-state members insofar as they would be getting both the supplement or subsidy from their employer and the cash benefit from the reimbursement, whereas the folks in-state who had gone back to work would not be able to take advantage of both an employer subsidy for the health insurance premium and the amount paid by the then Kentucky retirement system. Those were the arguments put forward and adopted by the court.
That's where I get confused. I don't understand why they can't get both. If the statute doesn't specify.
and I think our legal staff has looked at that and as the memo says, it doesn't have to be done that way. The other way that you're talking about, Ms. Pendergrass, is supported by statute. So that can be a decision that you all decide and we can move forward with that.
How many people does this affect right now? Do we know?
Connie, do you know the number of retirees who we have reimbursed?
Well, I believe we did that report, and I believe it was around 17
Okay.
for 2023. Of course, there's still some pending right now that can be processed through March for last year. There's a few probably.
17 total people, that's it?
Yeah, yes, sir.
Okay. Huh. Okay.
17. That's what we did a report and pulled a query. But last year was the first year they could do it.
Yes.
So, how much is the word out there? Yeah, we put it in the open enrollment books. We put it on the website, that kind of thing. And people do call and email and ask about it, but more of them are percentage, I believe, than the other. But
It went into effect January 1st, 2023.
yeah, so it's still somewhat new
Right.
to them, I think.
And wasn't also part of it due to the funding level of the health plan? Or is that
Not
something
this.
different?
That's something
Okay.
different, Mr. Powell.
Yeah.
All right.
This is their benefit that they get based on, you think about it, 7/1/23 forward, how many years you could have. And then that calculation changes a few dollars every year. It's $21.99 per year for a hazardous right now and $14.98 or 99 for non-hazardous. So, it's going to be $300 to $400 for 20 years. So that's what they're saying. So if you apply that to Kentucky Employees Health Plan, you remember the single level of coverage for that is $950 for the year. And that's the contribution the board said. So they're not going to have any, money to use on spouse or dependents. And so they may find a cheaper plan on the open market. And some of them do go to the marketplace and, some of those things. So they can seek reimbursement of per this new law now.
Okay.
And you remember that the Medicare eligible individuals who have this benefit are on the MA plans, which are costing the premium plan is like $93 a month. So see, that's probably why they aren't seeking it on the Medicare plans, because that premium usually does pay for their Medicare plan, whereas it wouldn't for the KEEP plan. So you're seeing non-Medicare retirees take advantage more than the Medicare eligible of this benefit.
Okay. Betty makes an interesting point. I mean, if it doesn't specifically say you back out employer paid, it could make a little bit of difference on some of these cases. Generally, when in doubt, I like to always benefit the retiree if it's not specifically spelled out. And this really affects very few people, at least to this point. But that's Jerry. You got anything on this? Sorry, Betty. Go ahead.
I think it's also consistent with some court rulings we've had on another case.
To not count the employer portion, is that what you're saying?
Not necessarily an employer portion, but making sure that the member gets the contribution rate that is specified in statute.
Okay. Jerry, any thoughts?
Actually, y'all have covered that every time I was about to ask that, somebody else would ask that same question. So.
Great minds, thinking along.
Okay. So we got, I guess we need to do two things here. We need to approve the reg and also improve the reimbursement option. So I'll seek motions for both of those.
So shouldn't we do the option first and then the reg, because that way we would actually know what part of the reg we're approving?
Yeah, I mean, we could actually, if you wanted to do one motion, make a motion to approve and then say which option you prefer.
Excuse me, Mr. Piercy. I think there was one more point in the memo considering the retroactivity.
Okay. You're right.
About that?
Yes, it is permissible for administrative regulations to have a retroactive effect so long as it is specifically stated in the regulation. And so another point for consideration is that if the committee does go with the recommendation for reimbursement option number 2, then the committee also should make a recommendation regarding whether the option 2 reimbursement calculation method should be retroactive to January 1st, 2023.
So there would be some refunds given to these 17 folks.
Yes, that's correct.
Since there's only a few and we're only going back a year, retroactive makes sense to me. I'd rather get it consistent throughout and correct from day one.
And just a point, there will be more than 17 probably, Mr. Piercy, because some people were denied because their employer submitted, paid more than their benefit what it was at KPPA. So there's a few more.
Yeah.
Thank you.
Okay.
But not a significant amount, I would say.
Yeah, I agree with Betty. I think that if we're going to do this option 2, then it should apply to the only year this is applied to so far, which is 23.
So is that a motion from Betty or?
Sure, I'll make a motion that we adopt the administrative regulation KR 1411 with the using the reimbursement option 2 as outlined in the materials from the law department, and that the change in policy will be retroactive to January 1st, 2023.
And I'll second that.
Okay, any discussion? Seeing none, all those in favor?
Aye.
Aye. Opposed? And that motion carries. And our last administrative reg is 105 KAR 1190.
Okay, so this is also an amendment to an existing regulation for qualified domestic relations orders or quadros. In this amendment, we have updated the language throughout for consistent language with all KPPA regulations and those definitions found in our definitions regulation. We have reorganized the sections of the regulation to add clarity. We've incorporated the partial lump sum payment option that is now available as a payment option for quadros for those received by the KPPA prior to retirement. Added details on how multiple retirement accounts affect the administration of a quadro. Added details about throughout this whole reg on to be more accurately reflective of the actual process of administrating quadros. And then we've also updated all of the forms incorporated by reference to add clarity to those, to make them more concise and user-friendly, and to reflect the agency name change. So do we have any questions concerning this regulation?
Can you summarize what the changes in the process were?
I don't think we've had,
Or highlight some of the big things that were changed?
some of the big things that were changed off the top of my head is just being specific in what, we have one quadro that can be completed by child support enforcement, and ensuring that we have the language correct in there, that it's not by order of court, but it's by the administrative body, and what the requirements are for them versus what the requirements are for the court. And then just lining out the process step by step on how we're going to notify when we place quadros in like a hold whenever we're waiting for things to be finalized,
So
things like that.
Dotting i's and crossing t's,
Yes.
kind
Yes.
of? Okay, all right. Go ahead. I'm too confused to ask a question right now.
Okay. My concern wasn't so much with the regulation, it was more dealing with your forms. When you look at that, it'll have their name and their personal identification number through KPPA, but it also shows the Social Security number as an option. And my concern is, since this is public, somebody could get a, Sherry, you need to look at 6434 is one of them. Maybe it's page before. Yeah, exactly.
A completed Form 60.
Yeah, there we go.
A completed Form 6434 with that information filled in would never be publicly available. It would be confidential under 61661, or the general requirement applicable to all governmental entities to maintain confidential or sensitive information like Social Security numbers, and that's 61931.
I just know I'd feel more comfortable if we would just use their PIN number as opposed to the Social Security number. And because errors do happen, and as we know, we get those. We have that release of the information from time to time. Through, it's not intentional; it's just accidental. But I just hate to see somebody have an identity theft issue from anything we would do.
We do require the PIN when they're doing things through their online portal, but we would not want to put the PIN number on a form, have them write this on a form, something like that, because I think that could potentially lead to some additional fraud issues, because that PIN allows the member to make some significant changes in their account.
Well, I think Jerry's talking about an alternative ID number other than Social Security.
Yeah.
You do give members a member ID. He's talking about that.
We do. The problem we see is a lot of times the members don't know their member ID. That's not something that they retain. They know their Social Security number, but they don't. We would prefer they put member ID on there. That would be our preference.
I think that's safer.
But it is, but we have a lot of members call in with issues because they don't know their member ID.
Yeah, and I would just say that we could certainly remove that as an option on all of the quadro forms. These forms are interesting in that they're unique for the KPPA because they're designed to be completed by a judge, by a court. And again, the judge, what's available to that judge or his or her clerk in completing this form may not include the member's ID number. So that may be a burden for some members in getting their quadro on file with us, is not allowing that Social Security number to sub in.
So my understanding is we were getting a lot of them without the member ID. It was just left blank, which would be not a valid quadro and causing administrative burden there and inability to process them. And then also with the child support ones, we actually have to have the social security number because we have to include it on the child support check.
Thank you. I forgot about that part.
Yeah, that's correct.
I was never on the recipient end on that, so I wasn't aware.
Aaron, just curiosity on this subject. When you, and because it's come up a couple times, when you get a QDRO for child support, is that something that is automated from that point on? In other words, when that date of termination comes, does KPPA automatically stop that?
If the quadro specifies it, yes, but otherwise,
Okay.
the member does need to reach out to the entity that originally issued the order and get a termination order. That has snuck up on some folks in the past, but we do try to make that clear and correspond to the member once the quadro is filed that they will need to follow up once it's time for that quadro to end, unless it states the termination date, which some of them do.
Okay. Any other questions or comments?
I had a question about, let's see, it's on page 6 of the regulation. It's the section that talks about taking the percentage allocated by the court to the alternate payee and then multiplying that by a percentage of the marital service versus the participant's total service. I was curious about why we were further reducing the percentage that is determined by the court and how that compares with the community property laws in Kentucky. Has the court already considered that marriage versus other issues in awarding a specific percentage, and are we authorized to change that percentage?
Now, that section 3, is for quadros that were on file prior to July 2000. And believe it or not, there are still a few floating around, I believe, that have not been kicked into effect. They're just kind of pending. These provisions have been around for 30 years, that particular section. The KPPA doesn't take a stance on what is or is not marital property. Parties may negotiate. You know, one party gets more of something.
Yeah, I'm familiar with that part.
But all we seek to do here is kind of give the court a couple of options to choose from based on what the court finds, based on the community property laws, or if the parties negotiate, so that, again, the court has a little leeway in what they can choose. But these are for quadros that are on file from prior to July 2000. It doesn't impact quadros that are coming in today.
So the language still exists in the regulation because we have some that are still out there that haven't begun to be paid. Yeah. Okay. Let's see.
Is that also true? Sherry, I'm going to page 85 in board books. And it's page 8 of the regulation where we're talking about what happens if a participant passes away versus the alternate payee. We keep paying the alternate payee when a participant passes away, but I'm not aware that when a member passes away that we keep paying their estate for what could be their actuarial benefit if they were expected to live to 92 and they passed at 72. It just seems inconsistent with some of the other things we're doing. And there's a provision later on in this regulation that I think it's section 22, 21, somewhere around in there, that if either individual passes away, then it stops. So
That's right.
I'm
So,
confused.
again, we're still in that section for quadros that were on file prior to 2000, and the statute 61690 prior to 2000 was much more hands-off than it is now. And at that time, under the this administrative regulation, in effect, in certain circumstances, an alternate payee could be eligible for a lifetime benefit regardless of when or if the member died. After 2000, quadros were not available, and then in 2010, the General Assembly again allowed quadros, but this time they added the language that you're referencing, Ms. Pendergrass, that said a quadro terminates automatically when either the member or the alternate payee dies. So it prohibited the alternate payee from receiving a lifetime benefit regardless of the death of the member.
Okay.
It's very confusing.
Very.
Very, very confusing.
Any other questions or comments?
Yeah, I think I'm gonna pass on the rest of the questions I had.
Did you have another question? I couldn't understand you, Betty. I'm sorry.
I have a long list of questions, but I'm getting a similar response. We have to do it this way because whatever, so
Okay.
I'm just gonna pass.
It sounds like the law has changed a couple times through the years, and so the different sections apply to different periods of time.
Right. I mean, we've got a whole section on orders before 7/1/2004 and after 7/1/2004. When I look at those two sections, they look identical, so I couldn't tell the difference between. I didn't know why we had two sections based on that particular date. What are we changing this July?
For 2024.
Right.
I'm sorry, I heard 2004, I apologize. So the partial lump sum payment option is now available. And for the folks who have not yet retired, effective July 1st, 2024, the KPPA recommends amending the quadro form to account for the fact that the member may come in later and select that partial lump sum option. Before, the form was set up for either a lump sum or a monthly benefit, not a combo. So this one pre-retirement quadro form now accounts for that possibility, effective July 1st, 2024.
Okay. That's it, Keith. That's all I got.
Jerry, anything?
No, I'm good. Thank you.
Okay, I'll seek a motion to approve 105 KAR 190.
So moved.
Second.
Any discussion? All those in favor? Aye. Opposed? And the motion carries. And that brings us to the end of our agenda. Appreciates everyone's attendance and participation, and we'll see you at the next meeting.
Thank you.
We're adjourned.
Thank you.
Thanks.